Danny wants to get our opinion regarding the right-of-way. According to Danny, he bought a land that is located just right beside a private subdivision. Danny wishes to improve his lot, but who would need to occupy a certain strip of land located within the subdivision so that he can have access to the road. Danny wants to know whether the Homeowners Association can deny him the use of the subdivision roads. Danny, if you have other means of getting to the main road or access to a road, there is no need for you to encroach or request for a strip of land in a private subdivision. The Homeowners Association are tasked to make sure that their rules and regulations are followed in accordance with the Magna Carta for subdivisions and homeowners associations. Remember that Article 649 of the Civil Code states in part, the owner or any person who by virtue of a real right may cultivate or use any immovable which is surrounded by other immovables pertaining to other persons and without adequate outlet to a public highway is entitled to demand a right-of-way through the neighboring estates after payment of the proper indemnity. Should this easement be established in such a manner that its use may be continuous for all the needs of the dominant estate, establishing a permanent passage, the indemnity shall consist of the value of the land occupied and the amount of the damage caused to the servient estate. To be entitled to an easement of right-of-way, the following requisites must be met. First, the dominant estate is surrounded by other immovables and has no adequate outlet to a public highway. Payment of proper indemnity. Third, the isolation is not due to the acts of the proprietor of the dominant estate. And fourth, the right-of-way claimed is at the point least prejudicial to the servient estate and insofar as consistent with this rule, where the distance from the dominant estate to a public highway may be the shortest. Remember, though, the well-entrenched doctrine that in order to justify the imposition of an easement of right-of-way, there must be real, not fictitious or artificial necessity for it. Mere convenience for the dominant estate is not what is required by law as the basis of setting up a compulsory easement, even in the face of necessity, if it can be satisfied without imposing the easement, that the same should not be imposed. Be reminded that our opinion is based solely on the information you provided us, and it may change any additional information. You are free to consult a lawyer of your choice regarding your legal concerns. Email us at newscenterptv4@gmail.com. Attorney J.J. Jimeno-Atienza for the Rule of Law.